on to this story now. Mine safety is back in the spotlight after 7 mine workers died at a Sibanye-Stillwater mine last week. To talk more about this, Ken Costa joins us now. He's a legal specialist in health and safety practices. Ken, thank you so much for coming through. So by virtue of these people that work in the mines underground, working some 4 kilometers underground, I imagine that's pretty dangerous already as it is, but there are certain pieces of legislation that, can potentially mitigate the dangers, and the Mine Health and Safety Act is one of them. How does this piece of legislation help us with regard to safety underground?
Certainly. Evening to Lesizwe. I think one must understand that this piece of legislation came about in 1996. It came in a time when this was an area that specifically needed to be regulated. And working underground, as you correctly point out, is quite a dangerous piece of work, stuff that you do underground. So what I think the Mine Health and Safety Act is really aimed at trying to determine that accountability. It's trying to determine accountability, but not only for the employer, but for everybody who works at a mine. The definition of an employee under the Mine Health and Safety Act is anybody who works at a mine. There's specifically 2 sections which are quite important, and that's Section 22 and Section 23 of the Mine Health and Safety Act. Section 22 says you must look after your own health and safety as well as the health and safety of your fellow workers. And then Section 23 says employees have a right to leave a dangerous working place. And I guess that's what the law says, and then it's just about ensuring that that actually gets implemented and is instilled in the culture. Now, I know that many mining companies do intend and do instill that culture, but it takes a lot of effort from everybody, including employees.
It sounds to me like a goodwill kind of piece of legislation. You do the right thing, you inform everyone what their responsibilities are, and everyone will be safe. Is it enforceable in terms of holding people accountable for failing to adhere to these?
Well, it certainly is enforceable. The Inspectorate of Mine Health and Safety have certain powers in terms of the Act, especially after an accident. And some of the things that can happen is that you may be called to testify at an investigation or an inquiry, produce documents which the Mine Health and Safety Act says you are required to have been responsible for causing them to be so, and it's after an inquiry and it's quite a rigorous investigation effectively into what happened. Either an employer or certain individuals can be held liable, both in terms of a financial penalty and or possible criminal sanction. Again, I think the most important point also just to remember is all of these things happen, and it takes time for these processes to run. But what's very important is that one must always stick to the facts. One doesn't want to speculate about how and what has happened until the DMR have had their full map.
Absolutely. In a recent interview, NUM spokesperson Livuani Mamburu said something very interesting. He said, before our members go underground, we always tell them they're empowered by the Mine Health and Safety Act to refuse to work in dangerous conditions, but they are promised bonuses if they work certain areas underground, and they're tempted because they earn poverty wages. I imagine that in your line of work, this kind of allegation is nothing new. You've heard this allegation before.
Correct. I think very often it is put forward that this is that the on-the-ground situation is that it's all good and well to have Section 22 and 23, but is it actually implemented? My experience of my clients in this regard is that they in fact do follow and do try and instill this culture of understanding that you can leave a dangerous working place. The other thing that's quite important to bear in mind is that many mining houses have structured their remuneration in such a way that safety is rewarded, if you know what I mean. So I think the idea that production only is the be-all and end-all is certainly not the case anymore. People are looking at whether or not if you can run the operation safely, you should be rewarded for it.
In terms of then the actions that the mining, gold mining in particular, gold mining companies have to take, those precautions that they have to take in terms of the Act, how much pressure are they under, given the pressure that the industry itself is under? Because I'm imagining, for instance, with an incident like the one we saw at Driefontein, that, Sibanye-Stillwater will have to show that they will be investing even more and more into securing that space in which their workers work under those already perilous conditions.
Correct. I think mining companies are under pressure to comply with the Mine Health and Safety Act. And as I say, it's not just about creating a paper trail, it's actually about that whole implementation of a health and safety culture. What is difficult in this context, of course, you would have read a couple of years ago about what we might term a possible abuse of mine stoppage notices, Section 54 notices. Now, even those stoppage notices, even though they are done under the rubric of ensuring health and safety, those health stoppage notices can very often result in even greater pressure on everybody, including the employees, to perform. And so I think we really do need to find a way in which we can implement the Mine Health and Safety Act in such a way that it can be efficient and efficiently done, smartly done. And we also do need the input from government, organized labor, to sort of say, guys, we're all in this together. This industry employs a lot of people in South Africa. And so it really is about creating a true collaboration. And again, there's the law and then there's the implementation. And I think everybody has a duty, including employees, health and safety reps, to really come to the party and to make sure that that operations can continue safely.